Hello. I've stolen her phone. I've stolen Miss Harsh's phone. You'll have to bear with me. I'm literally way behind. Way behind. Is it playing ads already? You fucking joke. I'm skipping ads. Bit of a different setup. I've got to get used to this setup. You'll have to tell me if everything's working. I've nicked Mrs. Harsh's phone to get chat. Let's just have a look and see what we got here. So this is Judge John Judge. He is he's not streaming anything at the moment. There's nothing on his channel. Nout on his channel. How is everyone? Who have we got in the house? We got My May in the house. Mod. Who else have we got? You have to bear with me. Like I said, I'm having a fucking nightmare. Kristen Superior Dreams. Aunt B. Hello, Aunt B. Kristen. Jen as well. My May. Huh? Yeah, I'll show her some love. Hello, Dixie. I didn't see you, Dixie. You're little there. I didn't see you, mate. I've got the chat down here on this screen. I've got that up there. We're just keeping an eye. While we're waiting, I'll get that back off the screen. So, I was over on Clue's channel. He was just saying that Dixie, yeah, I've been sneezing for about 2 days. Driving me up the wall. I think I've got an allergy to, I don't know, dust. I've got an allergy to court cases. But he's not on here at the moment. What are we saying, 10 minutes? Is BK in court today? He is in court today. He is indeed in court today. Apparently, well, there's a bit of a mix up here. I was over on Clue's channel and someone had reported that News Nation had reported that the motion to unseal had been turned down, but I can't find it. I went over to News Nation. I couldn't see that they'd said anything about it. So I don't know. Down the rabbit hole to hell. I've not heard of that, I don't think. How is everyone anyway? Bit of a different setup, innit? Oh, I don't know what's going on with that light there, though. What's going on? Not that light, that light. What's going on there? Is that flickering? If you've got epilepsy, heed this warning. Someone's flickering in the background. What is actually flickering in the background? Oh, I think it might be it might actually be the fire. It might be the fire flickering on the wall. I have no idea. Thank you. Yeah, a bit of a different setup, innit? That's because I keep changing things because I'm a lunatic. So the fire is now gone, and no, we still have flickering. That's not bad. It's not bad. I don't know what's flickering. Is it that? That can't be flickering in there, surely. That's a video light. Love from Lincoln. Someone from Lincoln in the house. Hello. Hello. So we're just waiting. We're really just waiting on whether Judge Judgeson is going to go live. I'm hoping that his channel's been live before, because if it hasn't, they may actually turn his application to go live down. Because usually your first live stream, you have to go live, and then you have to wait 24 hours, I think. Thank you, Karen, for gifting 5 memberships. Apparently, I can gift memberships, but apparently I'm an idiot and I don't know how to do it. Let me have a look and see if I can get over here and do it. I don't know how to do it. What have we got here? I'm going to see if I can do it. See, I don't have an option to do it. What's this shit? Create video highlight, insert ad, Add stream marker, which doesn't help anybody. Hello, everybody coming into the live. I have slowed chat down. Chat is slowed down. We've got a few people in here now. So, yeah, I have slowed the chat down. If we need to slow it down a bit more, I will slow it down. I don't like it being slowed down too much. I like watching you lot struggle. But, hello, Dixie. I like those hoodies. Yes. See, this is one of the hoodies that's going to be given away. There's this one and the one with the white writing. They are the two that are going to get given away. You're seeing how many people are subscribing to Judges and Judgy's channel. A lot. But I don't know how to gift memberships. When the flipping heck is that? But once again, it was Karen, Texas, who gifted the memberships. Feel free to try it on me, Mr. Harsh. Hello, Bertie, my friend. What am I doing? I'm trying to keep refreshing Judge's channel. We're still at the moment got Nout coming through on there. I hate waiting as well. Oh, bloody hate waiting. We'll give it what do we got? Crime Time with JB Gunner with the super chat. Hello, my friend. How are you? Cheers, my friend. Oh, have you finished moving, JB? I know you are moving. Stop. Yeah. Florida. Mr. JB Gunner heading to sunny Florida, I do believe. Evening Metalhead. See, I can actually interact with chat tonight because we're just waiting. I can use that as an excuse. God, I hate waiting. I've got a different mouse. This mouse is a bit annoying. Oh, yeah, it will. That's all right. Got a different mouse, JB. I usually use Apple mouses. Mice. Do you call them mice? Or is it a mouses? Apple mouse. I'm in Skegness, not far from you, Harsh. Skeg Vegas. Lovely. Loving the new studio. Thank you very much, Avril. Yeah, I don't know what the delay is on here. What is the delay? What's 6? Is it? Mental. 2 minutes. I think that's because of the... I don't know what that is. That'll be to do with the latency, I think. What we got? Excellent connection. Fuck knows. What do we got? T Hoppy gifted 50 memberships. Jesus. Thank you very much, T Hoppy. That is incredibly kind. You've just stitched up 50 people. They're going to be fucking well happy with you. Thank you very much, my friend. Everybody, thank you. Give a thanks to Mr. Hoppy and Karen Texas as well. Both gifting memberships. Hello, Pendizzy. We're just waiting. We're doing this boring thing where we are waiting for John Judge to and the latency. It is about 2 minutes behind, isn't it? It's literally about 2 minutes behind. That's fucking crazy. What's that? Thank you for being here. Thank you. Hey, hello, Brianna. Hello. I'm trying. The chat's mental. I slowed down as well. I have slowed it down. I don't know how to... It won't even get... there's not an option to gift on your phone either. Like I say, I've nicked Miss Harsh's phone. Oh, mate. What are we waiting for? Come on, Judge. Fuck's sake. You'd think you'd be a bit quicker on the ball, wouldn't you? More people hate waiting. Did you see that Kaylee's body... Yeah, Paris, that was... I was listening to that. That was in that interview, wasn't it? They were basically saying that in the room... The beds basically took up the entire room. There wasn't really any floor space. So they were talking about the positioning of Kaylee and Maddie, and apparently Kaylee was almost propped up and slumped I'm guessing it possibly against a wall, against the headboard perhaps. But that would but then you've got to think the latent footprint. Where did the latent footprint? That obviously came from downstairs, not upstairs. So that rules out technically that the person walked down the stairs and past Dylan Mortenson's room, and that's how it got there. It would have been interesting to know where that footprint was facing, whether it was facing the door, facing towards the stairs, or facing towards the house. So much there is a lot of kindness in the stream. That's because we're a kind bunch. We're a very kind bunch. We're a little bit slow on the old likes, though. Come on, hit fucking like. It's Miss Hoppy, not Mr. Hoppy. Oh. Sorry, Miss Hoppy. I'll give myself a slap. Ah, fuck. Ah. I actually properly whacked myself on the fucking knuckle. An overlay has been added. Resize it using the pit. No, I know how to do that. Why is it telling me to do that? I'm going to. I keep trying to refresh it to see whether there's anything on there. There's nothing on there. Absolutely nothing on there. Thank you very much, Artillery Amy, as well. I missed that because I've got less screen. I should actually look down there. That actually fucking tell me down there. Why is that not doing anything? Ah, yes, it did tell me. So I can't even blame the phone. It's just me being an idiot and not looking. So what is everyone apart from sitting around waiting for this just drunk tipping a friend? JB, mate, this could get really bad for you if you keep fucking doing that. If this goes so really bad, JB, and you end up tipping too much, mate, I'll send it all back. I hope you're well, my friend. I hope the move is going well. I do keep seeing what's going on. That's mental, isn't it? Don't slap yourself, send me a hoodie instead. I nearly broke my fucking knuckle doing that. Actually nearly broke my knuckle. That's what I get for trying to pay myself back for getting it wrong. There isn't a lot happening. What we saying? That wasn't it supposed to be what would be 9 o'clock PM my time. So he's got 2 minutes to pull his finger out. What do we got? Brianna. I've got to make that bigger. Why is that so fucking small? So we make that bigger. There we go. Let's pull that down there. Look. Is that better? That's because I wiped that off. This is a different laptop. That's why everything's wrong. I was thinking, why ain't that looking right? Because I'm on a different fucking laptop, aren't I? The dog is fine. The dog stinks, and if it carries on, he's going to be given away in a live real soon. It's just how we're going to get him over to the States or somewhere like that. We'll have to put him in a box. Could you imagine? He farts in a box. Someone will open it. That'll be like being punched in the face. He's such a treat, that dog. This channel is 18 plus. Harsh is like that, friend. You never put on speaker. What's that? Got a crazy 4-year-old running as she seems to fall asleep. Stand up, fixing 7 or 8. Basically, that's it. What do we got? My money is long. I ain't scared. That can go quick, though, my friend. That can go quick. Trust me. That can go quick. All further messages will be copied and pasted. Oh, what am I doing? I got still not scared. JB, you don't have to keep paying to fucking talk. Someone banned fucking JB from fucking paying. Even though I do appreciate it, you know I'm not Tyler Feller, don't you? We're not solely crowdfunded. You don't have to keep paying. Fake pasta. I don't mean like pasta as in food. He like pretends to be. Well, I think he is actually a pasta, but he also claims to be purely crowdfunded. Yeah, Gun Squad is in the house. He is in the house. And this is a moan-free zone. So don't fucking moan. I don't mean you, JB. I know you're probably fucking moan. I mean people who moan about other content creators. We get them, don't we? I know not everybody likes everyone. Not everyone is everyone's cup of tea. But over here, we don't give a shit. We just appreciate work and understand how much time goes into doing this. Ms. House, do you have an opinion? Oh, where the fuck did that go? I went to click on that, it disappeared.
Do you have an opinion as to what happened? Not asking you to swear to it, just what's your opinion?
My opinion, on what happened? Oh, Dope Soul's in the house as well. Hello, Dope Soul. I didn't see you there, mate. My opinion is that I don't believe that this was some random attack. It was very, very personal. I think this was an escalation that reached its peak, which kind of, it doesn't rule out Kohberger because he could have been part of something. Obviously, he could have been doing something in the background. We can't completely rule it out, but it doesn't make sense. So he is still a curveball. I think what wouldn't be a curveball. Hello, AR Hayes. AR Hayes is in the house. What makes more sense would be the argument that happened at the frat house. It escalated into what it escalated into, or a video that I'm bringing out tomorrow, which I would talk to you about. But if I talk to you about it, you probably won't watch it, and I'm not going to do that, am I? So check out the video tomorrow. The elephant in the room. Anastasia, member for 1 month. Thank you to whoever gifted me a membership. We do have a lot of people gifting memberships on this channel. The only person who doesn't gift memberships is me, and I need to find out why I am struggling to find it. Because I can gift memberships. I just genuinely cannot find it anywhere. Judge John Judge's channel is still not showing anything. Not showing anything. What do we got here? AR Hayes. Morning. Hair into unsealed denied. Who reported that, AR Hayes? Because the reason I ask is because someone said News Nation reported it, but I looked over on News Nation's channel and I couldn't see it. I genuinely couldn't see it. And it took me 10 times to send messages. JB Gunner, stop fucking paying. Jesus. Yeah, I couldn't see that they had, and it's like what Clue was saying. If they are reporting that, and that takes the piss because there's supposed to be a gag order, that heron was hidden to the public. It wasn't a public heron. So who the fuck got it out to media that quick? It's like Clue said. You got fucking Steve Gonsalves pretend to go out for a piss and text some I don't know, Brian Enton probably. I can take the piss. Feel like I'm lagging. I feel like this fucking stream's lagging. This fucking thing here. What's going on? Jesus, the chat's going fucking mental. What's going on with the chat? The chat's going mental. Bear with me 1 second. So let's see if I can slow that chat down. I think I'm going to have to try and slow that down, aren't I? How do we do that? Let me just go into here a second. Is it going to let me do that? I think it's just going to let me click back on it. Thank you very much for the super chats, guys. Thank you very much. I do appreciate it. Don't feel that you are required to do that, honestly. You honestly don't need to, especially with JB Gunner. He seems to be paying everyone. I mean, paying me for everyone. Which is probably not. He'll wake up tomorrow and be like, "That's the last time I go on a fucking live on a Friday night." Like, he'll be emailing me. Give me back my money. Aunt B, member for 9 months. Harsh is a 1,743rd subscriber. That seems like a lifetime ago. Not unsealed. Corruption at its finest. Fucking right. Absolutely. remember, I've got two lots of chats here. We've got a few things going on, for those of you who don't know. The things that are going on is you are about 2 minutes behind me. One of the chats is in real time. The other chat isn't in real time. And there's 910 people in here and we've got 493 likes. But we only have one thumbs down. So, tells me we've only got one tosser in. So, and we're trying to figure out what's going on John Judgy's channel. And at the moment we've still got fuck all going on, look. Nout. JB ain't scared, his money is long. The thing is, yeah, he's got a few quid, old Mr. Gunner. He's been doing this a what? Fuck off. Fucking hell. You work hard and deserve to be paid. Look, mate, I ain't Tyler Feller. We are not 100% crowdfunded. But again, my friend, I do really appreciate that. Now I've got 2 thumbs down, which came in about that 2 minutes, didn't it? I got Mrs. Harsh beside me, off camera, because she's scared. She's scared. Got Sienna as well. She's off camera because she's also scared. Or she's asleep because she's a bit of a hermit. And Jack agrees with me, but he obviously didn't say. Been out for some food, and now we're all in food comas. This is just me, like, I'm not even really here. This is like a hologram. Oh, mind you, if I was a hologram, I would have nearly broke my fucking knuckle. What we got? Stop thumbs down. The fucking knobheads. Doing it on purpose. What we got? Like your new background. Thank you very much, Bonnie. Thank you. What we got? Everyone smash the like button, or I'll smash you. Thank you, dope. Thank you all for being here with us. Thank you. Yeah, thank you everyone for coming over and staring at this channel, which is absolutely amazing. It's really good. Could you imagine someone coming on to this live like tomorrow? They're like on the replay. They'll be like, what the fuck? This is like the worst live ever. Worst live ever. Fuck that, I'm paying for my entertainment. I'm not Sky TV, Gunner. Now I got 3 thumbs down all at once. That was like a whole family. That was a load of people. They're even thumbing me down in the same house. In the actual house with me, and they're thumbing me down. She loves being a hermit. Hello, Mrs. Harsh, mum fist bump. You got a mum fist bump.
Someone put in the comment, Sienna, do you like your dad?
Yes, she does.
Some days.
Truth, Sienna, do you like your dad? Of course she does. I'm amazing. I'm amazeballs. But I have got a broken knuckle. Now I've got 8 thumbs down. You lot are taking a piss. Well, yeah. 8 thumbs down. Mind you, I've got 612 thumbs up, so that worked. I can take them odds. 11 now, look. Come on, look. Yeah, that's probably people here. That's Jack. They keep going up and down. That's Jack.
Yeah, it is.
Nice one. I keep trying to put my mouse over to this phone. That doesn't work, does it? Mrs. Harsh must come and say hi. She's here. She says hi. You can shout. They might be able to hear you. Hi. That was her. She just no, she doesn't sound like that really.
Oh, someone put Mrs. Harsh has the cutest laugh.
Not when she's driving, she fucking don't. She's angry as fuck. She's a worse road rage. And she's trying to say, I got road rage. I don't get road rage. Kathy White, and thank you very much. Let me just go through this quickly. The suits. Obviously, JB Gunner, thank you very much, my friend. We've got Hope and Francis, 6 months, been a member. I've got my own mods fucking paying. Stop paying. What did you say, Dixie? Y'all go hit that like button, and is JB drinking? Of course JB's drinking. I'd be drinking if I weren't on air. And to be fair, it's not that I don't want to drink on here. It's just I don't know what to say. I'm fucking bad enough when I haven't had a drink. I'll be fucking terrible. I don't ramble. It's on. It's on. It's on. Is it? Is it on? Let me just refresh. Oh, it is. It's on. What do we got?
Ms. Jennings, who is
Can you guys
here
hear
also
the?
remotely.
Let me just do this.
Mr. Nye and
I'm
Ms.
just going
Beatty.
to.
So we're
Let me just
here.
maximize
This is
the
an
screen.
open case. You
Oh,
probably
fuck.
know we had a closed hearing this morning, and that was
I'm
necessary
trying. I
because
can't
that
see my
was
screen,
related
so
to
that's okay.
the
I
grand
can see it.
jury, which is
Just tell me if the
secret.
he's live harsh.
So
Yeah, I'm 2 minutes
that's
behind you.
what
Don't
that
worry.
was all
I'm
about.
there.
I'm assuming that
I'm 2
you've all
minutes.
seen the
You are.
amended order governing courthouse and courtroom conduct.
Can you
We've
hear?
made some changes, and you probably also know that we are streaming now,
I'm behind you.
and that is on a YouTube channel.
I'm behind
If
you.
you
Why am I
don't
messaging
know
it? I could
that,
just say it. Oh,
you
that's
can
because the
go to
chat
the
would be live. You'd hear it.
Supreme
It's
Court,
on.
I guess, website, and you can get that channel if you don't have that already. So you don't want to be on a camera. You probably should leave. But
What I'm going to do, I'm
generally,
just going to move
we
my
can't see very
picture
well farther
just
back
down to
in the
here.
courtroom. So just so you're aware of that.
Make me smaller.
So today we are addressing reconsideration
Oh my god.
of the order
Get rid of
denying motion to dismiss the indictment, and that order is focused on the claim of inaccurate instructions to grand jury. Also coupled on that is the potential for permission for appeal for interlocutory order. So, and a stay of proceeding in the case. So I think that's all the preliminary. Ms. Taylor.
Mr. Logston will be arguing, Your Honor.
Okay, Mr. Logston.
Your Honor, I'm going to, I guess,
What's
be
Grizzly
succinct
doing in
since
there?
we argued almost the very same thing this morning. But in essence, what we're asking the court to do is to give us the court's blessing to take up the issue to the Idaho Supreme Court. I think the court has noted that it's certainly an interesting issue. The Idaho Supreme Court does have a rule that essentially lays out that this is to be done in very rare circumstances, important issues where people may disagree and that may make it more orderly in a particular case. Our argument is that for this case to exist, the indictment needs to be valid. If there's something wrong with the indictment, that's something that certainly should be addressed. We're also concerned about the fact that there is case law that says that if this case goes to trial, issues with the indictment may become essentially mooted by that and would never be answered. And there's relatively little in the way of case law in Idaho in the last 20, 30, 40 years. And so without permission to appeal, we may never get an answer on this. And certainly that's very important to Mr. Kohberger, because whether or not there's a valid indictment in this case is going to decide whether or not he sits here and whether or not a trial should occur, et cetera.
Thank you, JB.
One of the major issues is whether or not that's going to have an issue with the timeliness of this case. And my understanding is that's going to be the next argument that comes after this one. And so we believe if a trial is set out as far as we think it ought to be, that an appeal at this point won't disturb where we think a trial should occur in any case. And in any matter, this isn't our attempt to achieve some delay. This is our attempt to make sure that our client is getting due process at every step in this case, and that nothing is being left
Make sure
no stone
audio
left
comes
unturned. Thank you, Judge.
Thank you, Mr. Logston. Mr. Nye?
Thank you, Your Honor. I want to start with the rule that was just referenced. It's Idaho Appellate Rule 12, and it governs interlocutory appeals. And the criteria in that rule set out two factors the court is supposed to consider. The first is whether or not there are substantial grounds for difference of opinion. And on this particular issue, as the court stated in its order, the standard of proof for grand juries in Idaho has been consistently probable cause for at least 3 decades. That doesn't sound like substantial grounds for a difference of opinion. And in fact, the defense conceded in their opening brief on this issue that, quote, the whole of modern jurisprudence on this issue is against this novel theory that they've raised. So they haven't met that first factor. The second one asks whether an immediate appeal may materially advance the orderly resolution of the litigation. And I have not yet seen in their briefing or heard in their argument any path forward for them in which winning this appeal materially advances this litigation. I think if we're all being honest with ourselves, a trial in this case is going to happen. And the question is when. And if we send this case up on appeal, even if the defendant wins, the law clearly allows for us to bring the case back. Even if the Idaho Supreme Court goes out on a limb and says, you're right, the standard of proof in a grand jury should be beyond a reasonable doubt, we could use a normal complaint and probable cause hearing in front of a judge. So it would be the same standard yet again, and we would go in a whole circle, basically resetting the case to be where we're at today. We need to get to a trial in this case. And that brings me to my final point. I'll also try and keep this short. There are secondary factors that the Idaho Supreme Court has looked to in addition to that rule, even when those first two factors are met, to decide, is this actually the case that we want to take an interlocutory appeal? And my read of those secondary factors is it's really asking, like, what is the effect of this appeal on the litigation and on the parties and those involved? And I would just like to point out to the courts, under the rules, this is Idaho Appellate Rule 13F, and it's talking about the stay upon permissive appeal. And it says in F sub 2 that the granting of a motion for permission to appeal under Rule 12 by the Supreme Court automatically stays the entire action or proceeding until the appeal is terminated. So at that point, there's no more discretion. It automatically this case hits the pause button. But more than that, Your Honor, it continues and says, and during that time, the district court or administrative agency shall have no power or authority over the action or proceeding. We're not just talking about a stay in the proceedings. We are talking about this court losing its power and authority over this case while the appeal makes its way through the appellate process. That is going to cause significant delay. As we're about to have an argument or a conversation at least about scheduling. And there is a lot that needs to be done before this trial happens. And this court will have no power to address those issues if this case is pending on appeal. Now, in full disclosure, there are some exceptions to that rule, but it's the exact same exceptions that apply to an appeal as of right after judgment. So it's things like you can change the sentence, you can sentence the defendant, you can change bail, things like that. But for discovery, we've had the genetic genealogy issue that's still out there. We're working and making progress on, but pause button on that, pause button on discovery, pause button on change of venue, pause button on motions about experts and who can say what. It would significantly delay this litigation, which brings me to my final point, and that is I don't want to lose sight of the fact of the seriousness of this case. We are talking about a quadruple homicide. Under Idaho's law, not only are those who were killed victims, but every single one of their immediate family members is a victim. And in this state, in Idaho, our victims have a constitutional right to a timely resolution of the litigation. we are already quite a ways out. And the idea that we would hit the pause button and take power away from this court because there is a interesting issue for the Idaho Supreme Court to address is not something that this court or any court should tolerate. It's time for a trial, Your Honor. Thank you.
Thank you, Mr. Nye. Mr. Logston? Reply?
Judge, once again, we believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So the idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong and then see how long it all takes. We're asking that the court would give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in a case where the state's decided that it wants to try to kill someone. Thank you.
Excuse me. Well, first of all, this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while ago. It's rooted in well-settled law. And I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion.
It's a delay.
We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that established that it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal under Rule 12. So, excuse me, let me just get this in front of me. So the criteria for permission to appeal, this is in Rule 12 of the Idaho Appellate Rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. But this also has a second component. and this is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. And I'm very concerned about delay. And I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want. But I think that would add additional delay. As I said, I'm already concerned about that. We're over a year. Could be another year. I'll just let you all know that. Now, even if the Supreme Court takes up this appeal, or I deny it, and I'm going to deny the permissive nature of this. If I deny it, the Supreme Court can still pick up the appeal. That's up to them. But they do look at what the district judge's opinion may have some bearing on that. I hope so. But they could still overturn the orders of this court denying the motions to dismiss the indictment. And they could dismiss the indictment. What would happen then? Okay, is this going to really materially advance the orderly resolution of the litigation? The state could just file it, refile it, as Mr. Nye said. So that's significantly more delay. So there's some other, actually, this is in a case law, Buttle versus Todd, where it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood or possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. But it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal, obviously denying the motion to reconsider. And with that, I think we are ready to go to setting a trial, or at least a schedule order. So anything else about this issue before we go to that? Ms. Taylor?
No, Your Honor, thank you.
Mr. Thompson?
No, sir.
Do you want to go first, Mr. Thompson, about the state's position on scheduling?
Yes, sir. I'd be happy to. And to start, Mr. Logston said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says In cases such as this, with facts like this, a jury is entitled to decide not only guilt, but potential felony. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone is just simply appealing to raw emotion, and it has no place in this court. We would ask that that not be allowed any further. Now, as to the trial, Ms. Nyer already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, which he has waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want Your Honor, to take into account, and certainly we want to afford them that opportunity. I will say, though, that we touched on this in our motion, in our request for the scheduling order, that given the nature of this case, if we are going to try this case effectively with minimal unnecessary harm or disruption to our community, it should be done during the summertime. And I say that because right across the street there is Moscow High School that shares parking all around the courthouse with everybody else who's going to have an interest in this case and being here. And we've already encountered the conflict between those interests. We can't sustain that for weeks and weeks on end. That's just not fair to the students. It's not fair to the school district. It's not fair to the media. It's not fair to anybody. The other factor is, as Your Honor knows, we have two universities, part of our community. And during the academic year, we have graduations, we have numerous sporting events and other university-related events that essentially consume every available hotel or motel room within miles. This case is going to involve bringing in people from out of state, numerous witnesses from out of state who will have to be put up in lodge. And we would submit that that's going to be unnecessarily complicated if trial occurs while the universities are in session. So those are the considerations that we have, Your Honor. As I said, we filed this last month. At that time, and as we stand here today, we believe that we could be ready for trial this summer.
About him going on about
Thank you, sir.
Thank you, Mr. Taylor.
Thank you. Your Honor, I received Mr. Thompson's motion for a scheduling order, and I had the opportunity to meet with him and talk with him and Ms. Jennings about that. So it is no surprise to the prosecution that we do not believe a summer of 2024 trial is realistic in any way. Understanding the state's concerns, if a trial were to happen in Latah County, we would suggest looking at summer of 2025. However, counsel and the court's aware that our intention is to file a motion for change of venue. That hasn't been filed yet because we're not ready to have that heard yet. There's work that has to be done to present to the court and counsel in support of that. So that's just for the court's information. Your Honor, that in the state's scheduling order, it asks the court for various things. And a lot of those we don't have disagreement with. We think they're appropriate. And in fact, they were things that were covered by the court in the court's original scheduling order. As the court and counsel recalls, last fall, we had not made the choice to waive speedy trial. And so the court did a scheduling order at that time. It wasn't but a few days later that we'd had enough time to discuss that. And Mr. Kohberger decided to waive his speedy trial. And the court vacated that order. So I'm familiar with what the court likes to put out there as far as a scheduling order. And I don't think there's a problem with that. I would want to inform the court that I do not believe this is a 6-week trial. I believe this is more like a 12 to 15 week trial. This is, as everybody said today, a very complicated case. And I want to talk a little bit about what drives both our request no sooner than summer of 2025. And I say that with fear, Your Honor. There are a lot of things that we have to still do. I want the court and council to know that we haven't sat around waiting for a scheduling conference to begin doing those things. We have been on this case and active and seeking discovery and reviewing discovery, meeting with experts and working the case since the day we were assigned this case. So with that said, there's still plenty to do. And I want to talk a little bit specifically about that. In a case where there is the potential for a death penalty, we're looking at two tracks of trial. We're looking at the innocence phase where there's tons of witnesses and a lot of things that happen. And if there is a guilty verdict, we immediately go to a sentencing phase. That's up to the jury what happens there, but both parties have to be ready to proceed forward. So we don't get the luxury of focusing on our case, the state's investigation, our own investigation solely. We focus on that. We are working on that, but we are required to begin our mitigation case. That's what it's called, the penalty case. We are to put on mitigation. We are guided by the ABA standards, American Bar Association standards in capital cases. That's what this is. A death penalty case is a capital case, and we're guided by those standards. And they tell us that as attorneys, we must investigate every aspect of the case in the innocence phase. We must meet with our client regularly, which we do. We must engage in experts and understand the issues that are coming, which we are. The American Bar Association guidelines in capital cases say we must hire a mitigator and there must be a mitigation investigation. We hired a mitigator, probably one of the very first people we contacted. And so that has been ongoing for 13 months almost as well. We have not been sitting back and waiting. Your Honor, in this case, the complexities are that there are special areas of focus. And when we get to trial, counsel for the state will put on experts to educate the jury on specific areas of focus, as will we. And it takes a while to get all of that done. In addition to that, as the court knows, everything is recorded. There's digital footprints all over the place. And so we have a lot of records that we have to go through. I know that the court has heard about 51 terabytes of information that we've received. And I want to tell you what that means. Ms. Massa found a statistic for me, and I want to tell you how much 51 terabytes of data is. And she found that. She was looking at Dropbox.com, and 51 terabytes of our discovery, to put it in perspective, 1 terabyte can hold 250,000 pictures. 1 terabyte, and we have 51 of those. Or 500 hours of high definition video, and we just have one of those. So 500 hours times 51, or 6.5 million document pages. And that's equal to 1,300 filing cabinets. And we have 51 terabytes, not just one. So that's a lot. There's specialized knowledge. There's a lot to go through in this case. We also have another player in the case, and that's the presence of the media. This is a case that has drawn a ton of attention from the media, and it continues to do so, and I don't think that's stopping anytime soon. The impact of that is that we have found that when we want to talk to witnesses, sometimes they don't want anything to do with us. Sometimes they're people that have already talked to the media too much, and so we shouldn't talk to them or bring them into the case. So that's just a complication. We're working through it. We're working around it. But that's something that the court has to be aware of. I want to let the court know that there are over 400 potential witnesses in the innocence phase alone. I personally and my team have talked to less than 10%, well less than 10% of those witnesses. In the mitigation phase, our mitigation expert has been actively working the case. We've all been working alongside our mitigation expert. There are still well over 100 people left to try to contact and try to interview. And let me back up and explain what we do with mitigation. We are to learn Bryan's life story. We are to go all the way back to before he was born and learn his life story. We have to be prepared to talk about that in different ways. But it's not just a life story. We're required to go 3 generations back on each side. mom and dad. The court can imagine that there are a lot of documents that must be collected and examined and reviewed so that we are aware of things that we would need to present to our jury if we ever got to that phase. We have had a lot of trouble collecting documents. Sometimes it takes a court order to get documents. Sometimes documents are missing. Sometimes they're very old and you have to piece things together. We're working through it, but I want the court to know it takes some time for that as well. There are records yet to be obtained that we need in both sides. There are still experts yet to be hired that we need to find an expert that has the right expertise and will work on the case with us. We do have several, we're working with them, but there are still more that need to be found. And then let's come back to the discovery. I want to talk about some of the difficulties with discovery, and I want everybody to know that I am not disparaging the state when I say this. I'm describing a complication, a challenge, probably one that the state shares. In this case, we began asking for supplemental discovery in February of 2023. We had some initial discovery, and then we started looking at it and asking for other discovery. We are up to our 11th request for discovery, and there's, I think, 250 items total with subparts to that. The state will respond to us. They're not ignoring us. I'm not saying that at all. There's just a lot out there. But this is complicated because the discovery that we receive, the materials, there's videos, there's interviews, there's police reports, there's photographs, 13,000 photographs that come in, and they are not indexed. So you get a discovery file and there's tons of sub-files, and I believe this is the way the state's getting it too. And I believe this is complicated because we have multiple law enforcement entities that have been working on the case, and I believe they filter discovery through one of the entities and then it gets to the prosecutor. And I think they're hurrying as fast as they can to get the discovery to us. So I think they're giving it to us as they get it. But there's no indexing in it. So you must open each of those files and see what you have. And you might have police reports in sequence, and then you might not. And you might have photographs, but you don't know which officer took them. You can tell where they are, but you don't know which officer, and you don't know what day because the officers were in that residence multiple times. So that's complicated to try to match all of those things up. There are things that we've asked for that have taken, it's just taken a long time. The court knows we've had motions to compel, and we've had some pretty lively debates about what certain things that we should have and certain things that they don't want us to have for other reasons. Those things take time as well. We don't have complete discovery. I don't think the state has complete discovery, but we definitely don't have complete discovery. I'll give you a couple of examples. There is a video that's a really important video, and we early on received some of it. And we are still waiting for the complete of it. The court would know from our 11th discovery request that there's still outstanding portions of that video that we need to have. And I think the state's working through it, trying to match up video and sound together for the completion, the full several days worth of video. But there's not even an estimated day when we'll get that. And that is critical for us to review and hear all of that. So that's an example, Your Honor. That is not us saying we just don't want to go to trial, we just want to drag our feet. That is us saying there are critical things that we don't have. I am very concerned about expert reports. We have a draft of one, the cast report. The court had ordered that we receive the cast report. It's a draft. I don't think the state has it. I don't think they're sitting back on it, but I don't have that yet. And there are completed materials all over the place like that we just don't have. Our team speaks with the prosecution team fairly regularly about these issues. We communicate by text and by email about things like this that are coming up. We've sat down and spoken with them. They're very open to talking to us, but this just isn't a closed deal. there has to be a deadline on discovery. There has to be a target date where that ends. And then there has to be time to make sure that we've read every piece of it, watched all the videos, looked at all of the photographs, and know where they came from.
Just testing them
A
out.
few months from now is not a sufficient amount of time to do that. There is no possible way I can even read or watch everything I have now or react to things that are still coming in if we're to have a deadline in time for a summer of 2024 trial. There is no possible way that I would be effective in my investigation, in my presentation to a jury, if I don't have the state's expert materials ready to give to my experts and then give them a report to respond to. There is no way that I am effective assistance counsel if I haven't looked at every bit of discovery that's available. Recently, Your Honor, as recently as January 4th, we received discovery that contained over 9,000 tips that law enforcement had obtained. And we've had, this isn't a new issue, I think the court's heard about this before. We've had bits and pieces of tips and they've come in and we've reviewed them, but the 9,000 new ones we received January 4th, those were closed out in October of 2023. And I don't think the state sat on them. I think that's an example of the process that they close them out so they can give them to us. But they go through other agencies before they get in the prosecutor's hands to give to us. I have to read every one of those 9,000 tips. There are things that matter to us in our innocence phase that have come up and been done. And I have to read them and appreciate them and react to them and see what's there. That's the duty I owe to Bryan. That's his right for effective assistance of counsel to have me do those things. Your Honor, summer of 2024, it's impossible for us to do it. Our team constantly meets, we constantly work. We are on this. This is our priority. Bryan's our priority, but we are not going to be ready in June 2024. Your Honor, I want to also talk about some of the other deadlines. One of the things in the state's motion for scheduling order had to do with the alibi defense. And as the court remembers, we had made some submissions and we needed more information before we could do anything more complete. We're still in that circumstance. But when the court vacated its scheduling order last fall, that was part of the scheduling order that was vacated. So the state asserts in its scheduling order that our time has expired, and that just can't be because the court didn't carve that out and say, I'm going to vacate everything but this. So we'll need a new date, but I'd ask the court to be really mindful of the other information we need. We need the cast report. We need other information of things that past agents and other specialists with the FBI might have done with cell towers and records. And I don't have all of those yet. I have some. And the state has pointed me to places that they believe I have more that maybe I missed in the discovery, and I'll look at those. But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over and over again, and I'm not sure. Over a year into this case and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together. And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to allow windows to file additional motions based on later disclosed materials too. I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well. I think that covers it.
Thank you. One more question. So
sure.
I understand this. I mean, I'm aware amount of disclosures already. But do we need a whole nother year after this summer? I mean, can I help everybody by having tighter deadlines to make things happen faster so that we can get this trial sooner?
That's a tough question. If the state says you have everything, and I believe they could say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. There's not a shortcut for the amount of time that it takes to go through everything. There's just not a shortcut for that. Having a deadline for discovery helps me. It just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say, everything's going to go according to plan, I'm going to give you these deadlines, and all of the materials will be in the state's hands so they can give them to you, and the records you need will be given to you when you ask, and the witnesses that you need to speak with won't slam the door in your face. If you could tell me that, then I would say I could be ready by March of 2025. And that's me saying I'm going to spend every possible hour on Mr. Kohberger's case, which I've been doing and which I'm willing to continue to do, and so is the rest of his team. But my problem is that's best case scenario if we don't run into problems and delays getting records or getting people to talk to us. And if the next calls I make on the experts that I don't have yet secured, if they say yes and they're ready to go and have time to take it on, that's best case scenario. I'm nervous telling you I'll be ready by summer of 2025. I'm nervous telling you
that. This is priority for everybody, and I want to be realistic about it. I don't want to set it more than once. I only want to have one trial, one time, so it doesn't come back. We can only predict the future so much. I only have so much power. So I'm relying on counsel deeply. So let's go to Mr. Thompson and see what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. It's kind of like you ask one question, you get an answer, and that leads you to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We are trying to provide things as quickly as we can, and she's right. There are delays with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000, I didn't count them, but there are thousands and thousands of tips, most of which are out there, but you're right, most of all of which need to be looked at to see if they have any potential relevance to the case. As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic about being sure that we can get our witnesses here. We'll have something to put them. and there won't be undue interruptions in the community that can cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And, I don't think that's going to change anything, Judge. When this case has national, if not international, attention. This spring, I was at Association of Council of Counties board meeting in McCall, and there was more news every morning from Boise on this case than we see up here. Every doggone morning. I have friends in this community who have traveled to Mexico, and they say, people here were from Moscow, and immediately they want to talk about this case. It's not Moscow, it's not Latah County, it's everywhere. So I don't think that a change of venue is going to solve any of these problems. And the state's position on venue is that the case should be held here. It's a Latah County case. We believe that we can select an appropriate panel of jurors from Latah County. We have the tools to work with that we've discussed with Your Honor. In fact, we already have a fairly comprehensive draft juror questionnaire to send out so that the court and counsel can assess the level of knowledge and the feelings of the potential jury pool. But we think that we at least owe Latah County, the people of Latah County, the attempt to seat a jury here first. And not just rely on, there's been a lot of publicity. There's been a lot of publicity everywhere. The only place I've heard that there wasn't publicity is in Lewis County. Somebody was talking to a court down there, and they happened to mention Kohberger and said, what are you talking about? So if we want to change venue, I guess we could go to Nez Perce.
Kind of small.
It's kind of small. Lodgings aren't very good as far as a lot of lodging. But I think that is a practical observation on this case. It's not just here. It's not just Moscow. It's not just Latah County.
Okay. Thank you, Mr. Thompson. So you're saying, looking at this realistically and the amount of information, evidence, non-evidence, that you might be looking at summer of 2025?
I'm saying that could be where we end up, Judge. I am still concerned about the victims and their families. I mean, they have suffered for well over a year now with a lot of uncertainty, and that's painful. It's an everyday reminder, and they need some certainty and they need some closure in a timely fashion. But we know we also have to make sure, as Your Honor just said a few minutes ago, that we only do this case once. That it doesn't come back on appeal, that it doesn't come back for subsequent things saying that somebody made a mistake. We want to do it right. And the factors are in front of Your Honor. I think that you're certainly in a good position to make the best decision.
It's a decision that pulls me in two different.
I appreciate that, Judge.
Yeah.
No,
it's too late.
I don't want to set it right now. I mean, I'd like to get a little closer with discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe March 2025, which Taylor, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. Going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times. Because no matter what happens, okay, if he's convicted, it's going to be appeal, and that's also a challenge. So my heart goes out to the victims. I can't even imagine the pain, the grief, because you can't really go forward with your life with this hanging over your head. So, I'm sorry. We'll see. All right, so I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently. And I want to do the right thing. Okay. So, does that conclude what we need to talk about today, Mr. Thompson?
I believe so, Judge.
Okay. Ms. Taylor?
Yes, Your Honor.
Okay, well, thank you all. We are adjourned.
Kohberger's defence team. BK. How's it frozen? Hello. Is my mic back on? Is my mic back on? Oh my god. Well, that was an experience. That was an experience, wasn't it? So we're saying a trial sometime in 2025. Yeah, Lady Red, see y'all in 2026. Ain't that about right? But change of venue. I think just the interaction between Father Christmas and Judge proves that they need a change of venue. Change of venue, like Denise says here, to a non-college town. We've got to do that. But I found that quite interesting, the way that Ann Taylor was handling what she was talking about. She made him sound guilty. I don't know whether that's just me who thinks that, but Ann Taylor in that hearing made it sound like he's guilty and they've got to try and argue why this happened. I could be wrong, I could be reading that wrong, but that was how that came across to me, almost like we've got to go through everything, talk about his past, talk about him growing, and all this. I just don't get it. He already has BK pegged guilty in yes, change of venue. He does. They have him pegged guilty 100%. They're going for him. For me, for me, that sounded like, no, she didn't. I don't know whether that's in response to me. That's how it sounded. Like, I'm just someone listening into that. Do you know what I mean? I'm just a layman listening to it. But to me, that sounded like it was about building a case to make an excuse as to why this happened. Again, I could be reading it completely wrong, but that's how I'm reading it. Denise, you see, and this is just about perspective, isn't it? This is just about people's perspective. Some people are going to read it differently. Aunt B, hey, real harsh, I need to go. Thank you for all you put into this case, as well as others. I'll be listening to this again. Thank you very much, Aunt B. Thank you very much. Have an awesome rest of your day, and thank you to everyone else who is here. There's a fair bit of us, and it's very, very frustrating. There was some really frustration elements to that, but again, Leslie M inadvertently, but she did make it sound like he was guilty. And again, it might not be what she meant to do 100%. Well, I'm not saying I'm now jumping into a different position on Bryan Kohberger. He's still entitled to his shot. Do you know what I mean? But to me, 100%, that Ann Taylor, my interpretation was that she made him sound guilty, and it's going to take this long to go through everything, get all of their story together and build why this happened, to make a case for people to perhaps feel sorry for him, or this is how we got to this point. But I felt Anne herself made it sound as though he would be found guilty. And again, but we have someone I respectfully disagree and don't think she meant to do that. Again, I don't think she meant to do that. She was just telling them how overwhelming the material is to go through, and how she can't even figure out why they picked BK. And again, that's it's good that there's people like yourself out there who got that from it. But the danger is there's people like me who would have seen it like that. And that is that, my opinion is, this isn't as simple as he didn't do it. There was none of that in this. He didn't do it, and we're going to struggle to prove that he didn't do it. We need time. We need time to prove to you guys and prove to the jury that this is the wrong guy. She started going on about, we're going to have to dig into his past and tell you about his family and his growing up. Do you know what I mean? That's almost like excusatory, isn't it? That's the realm of excusatory. I didn't think she made him sound guilty. I think she's trying to cover all aspects. And I hope you're right. But it is what it is. But anyway, we've been here long enough. I'm obviously going to discuss this. We'll shorten this down for people who didn't get to see it and cover some points that was gone through. But the takeaway points were, we've got to wait, likely 2025, even 2026. It didn't even sound like they felt 100% confident it would be next year. And we've just got I'm going to perhaps watch over this again and just make 100% sure what I caught from Ann Taylor. But like I say, I'll shorten this down, I'll put it out there. I've got a video already plugged for tomorrow, which will come out. The other one will probably be Sunday, or I'll do a live Sunday. We'll do a live Sunday, a reaction to this, so we can get back together once I've watched it again, and we'll go over it all then. But thank you so much for everyone who joined us. Thank you to the mods, you're doing a fantastic job. Thank you to everybody. I missed a load of the super chats and everything. Thank you to anyone who did the super chats and gifted memberships. That's absolutely amazing. But for now, I'm out of here. Until next time, I will catch you all in the next one.